When I
Slow down.
received the judgment, I
Slow down.
contacted the.
Slow
Yes, sir.
down.
Okay.
Slow down.
Okay.
You just got done telling me you did not receive the judgment. Now
I
you're
did
saying,
receive the judgment. I'm sorry. I'm referring about the. I got another court case, that paperwork that is in front of me too. So I'm sorry. That was my. I'm sorry. I apologize, Your Honor.
okay, just
I
stop
did receive
talking.
the judgment.
Stop talking, please. You also told me after you said that you didn't receive the judgment that they never told you how much you owed them. If you received the judgment, it's right on there, correct? Do you have a copy of the
I'm
judgment
speaking
in
about the
front?
conversation that I just. Okay.
I don't know. It's big. I'm wondering if my forehead says I want to be interrupted. It must. It must say that. It has to. You have the judgment in front of you?
I just got. Yes, I have the judgment now in front of me.
You see what it says that you owe?
Correct.
All right.
I do see it.
Okay, so now you know what you owe. How much do you think that you owe? Give me the exact dollar. Don't just tell me I made a payment or I made payments and I don't owe this much without telling me the exact amount that you owed.
I can't give you an exact amount
Well, then how do you know that you don't owe this?
because like I stated before, Your Honor, I have paid into my debt. I was
That's,
paying into my debt until I
ma'am,
lost my employment. So I
what
was
is the,
paying my debt every week, every 2 weeks that they had me paying until I lost my employment.
all right, Mr. Payne.
So I'm not aware. I have to go back and
Okay,
find my
you don't
actual
know.
receipts and things.
You said it 45 seconds ago. You don't know how much you owe. Mr. Begg,
Not the exact amount. Not today. I do not.
well, you're coming to court and you're asking me to set aside a judgment, and I have to
Yes.
find that you're interrupting me again. You're starting to, and I have to find that there is a meritorious defense and good cause to set aside the default judgment. You're saying you weren't served. Somehow they had you at this family-owned location, and that's where all the paperwork was sent, and they obviously must have applied for alternate service. If you didn't live there, you couldn't have been served personally there, but they can serve in certain circumstances by alternate means. First class mail, tacking, certified mail. So I'm kind of surprised none of your family members that live there would have told you about this, but that's neither here nor there. I'm going to look at the proofs of service. Mr. Begg, tell me how much the interest rates are on this one.
Let's see, this should, post-judgment interest, is at 4.72%. I told her balance is, $6,581.89.
What's the prejudgment interest at?
I'm not sure here. Let me see if it's,
Take
in
your
here.
time.
It looks like, prejudgment interest, was waived. If I'm looking at the, uh, default judgment. Had no contract with, LVNV funding, but, she's not a party to an assignment, so she has no standing to challenge it. There's definitely no meritorious defense, here, and the alt service, was properly, ordered and completed.
Anything else, Ms. Thomas?
Yes, Your Honor. Respectfully, I just asked the court to set aside the default judgment. I wasn't properly served. Um, I just wanted a chance to file my answer. Um, I still didn't, like I said, I just didn't know the total, what they're saying that my total amount of the debt was. Like, that was my question. I didn't argue with anybody. You know what I mean? He asked me a question and
But you
I
know now,
responded.
right? Because you found the judgment that you said you didn't have. You know,
What
right?
Yes, sir. Absolutely. I know today. Yes, I do.
Well, you would have known from the time you got the judgment, right?
I got the judgment. Yes, I wanted to be able to obviously be able to appear in court. I didn't want a judgment filed against me. I wanted to be able to have a say to at least prove or have a chance to argue my point. Um, I wasn't able to appear in court, so obviously a judgment was already rendered against me to pay total amounts of court costs and the judgment, which I felt was unfair because I wasn't, like I said, I wasn't able to come and at least um state that, you know what I mean, just be able to give my answer or at least ask the judge, ask your honor to at least be able to have them show me my total amount, prove to me my total amount because I have paid into them. This is not a debt that I just out got and didn't pay into. I was paying my portions of my debt on time. I lost my employment and my home, and so that became an issue
You filed your
for me.
motion on March 25th, which would have been after you received the default judgment.
Yes, sir. I
So
did. I
if you
called.
were coming to court, you needed to come forth and say, this is all that I owe and here's why, in a written document. You didn't do
Okay, I
that.
didn't know that. Right, I didn't know that. When I spoke to the
Sorry,
court clerk, I'm sorry. I
I'm good. Good.
Okay, so when I contacted the court, she explained to me that a judgment had been rendered and that this is what I needed to do to have it set aside or at least get a court date to speak with Your Honor. And so that was what I did. I was so fearful of the default judgment being placed against me. I came in immediately the next day. And so that's when she told me that I had to file this paper for XYZ, pay this money, file this document. You're going to write on the document what you feel is the reason why you didn't appear in court. And that's what I did. I didn't know I had to do, you know what I mean? I didn't know I needed to make another statement in regards to the monetary portion of the judgment. I didn't know
Okay.
that.
So I have to find good cause and a meritorious defense, and I just can't do that, Ms. Thomas. They properly got alternate service.
I
It
never
was,
read. How can you?
ma'am, let me finish. They complied with the order for alternate service. You didn't answer the complaint. You don't know what you owe. You're just saying you paid some of it. A lot of people pay some of it. I cannot find that there's a meritorious defense here. I'm sorry, I'm going to deny your motion to set aside default judgment. If you would
Wow.
like to, if you would like to, you can file a motion for installment payments. And or we can even do that now, Mr. Begg, if you'd like. And I will be glad to accommodate you with a hearing, determine how much you can afford to pay weekly or bi-weekly or monthly. I'll be happy to do that now, and I'll waive a motion fee if you choose to do that now. Would you like to do that?
I mean, if that's all I have, I mean, yeah, because you saying you're not setting aside the judgment, I can't even fight for that. So at least I can't afford to give them. I don't have $6,000 to
Ma'am,
give to anybody.
ma'am, really, I'm not going to argue with you. If you want me to conduct that hearing, I will, but I don't want to hear another word about my ruling. You can appeal that if you don't like it. Please feel free. I'm not always right. If you want me to do that now for you, I will. I'll swear you to an oath, and Mr. Begg can ask you questions, and I'll ask you questions, and I'll figure out how much you can afford to pay on a weekly, bi-weekly, or monthly basis. Do you want to do that?
Do I have to do that today? Can I have a hearing for that?
No, you can do it. You can do it later, but you're gonna have to come in and file a motion then. Okay? And you can request that the motion fee be waived if you qualify for indigency status under the rules, okay? So yeah, you can come in and fill out your motion. Right now, council, send me an order denying motion to set aside default judgment. You file your motion. I do it sooner rather than later, and we'll set it for hearing, okay? Thank you very
What
much.
is the motion
Thank
that
you,
I
Your
need to
Honor.
set?
Council, wait. You can file a motion for installment payment order. Okay? Good luck to you both. Thank you. Derek
Thank you.
Tanbelda Fernandez, 25W707-530. Defendant is compliant, community service and domestic violence program completed, mental health treatment compliant, balance zero. The defendant's inpatient, and I just got this stip from the prosecutor. Case dismissed. This was taken under 7694A. I'm going to waive his presence today in light of the fact that he's in an inpatient facility. Case dismissed. Defendant compliant. Defendant could not appear, but I'll waive presence as defendant. Is entry. All right, that's what I'm going to do. All right, now, what else do I have here? Do I have Capital One versus Scott R. Voida?
Your Honor, the parties are still in a breakout room.
Do I have Betty Breeding versus Dakota Richter? Come on up here, please. 2600603.
Right to the podium here.
Morning.
You two want your name, ma'am?
Oh, Betty
To
Breeding.
the podium. Next door.
Sure, your name? Do you want to talk about this out in the hallway? Yeah.
I gave him chances to claim it.
Are you a heating and cooling guy?
I do it on the side.
You want to go talk, see if you can resolve it?
I mean, we've talked, obviously, we're here now, we need to go.
Okay.
All right.
I don't believe what she's trying to get was necessary.
Fair enough. You guys, by pursuing the small claims division, are giving up certain rights. Each of you are giving up the right to a jury trial. Each of you are giving up the right to a lawyer. Each of you are giving up the right to appeal my decision, and to the extent that you might be entitled to it, plaintiff, you are giving up the right to seek in excess of 77,000. It might, has it gone to 7,500 yet, Jen?
No, Your Honor, it still stayed at
Still
7,000.
7,000. Okay, they're always raising it every, what is it, maybe 8 months or a year, but anyway, 7,000 is the max, but you're only paid for 700. You don't have to give up those rights. If you want to preserve those rights, just tell me. I'll remove the case to the General Civil Division. I'll still be the presiding judge over the case. But if you proceed in small claims, like I said, you're giving up the right to appeal my decision, the right to a lawyer, the right to a jury trial. Do you understand that, Ms. Breedy?
I do.
Do you understand that, Mr. Richter?
Yes.
Do you wish to give up those rights and proceed here, or have the case removed? Ms. Breedy,
We can do it right.
you waive those rights? Mr. Richter,
Yes.
you waive those rights? Raise your right hands. Do you have any witnesses? I'm asking you.
I have a person that did the work.
Where's he at? Is he coming today?
No, he's at his job.
You want to call him?
I forgot my cell phone because when I was leaving.
Well, I'm just telling you, hang on a second. I don't know what you're talking about with the parts here you're talking about. If you think he did something wrong, you're gonna need to prove that.
Okay. He never finished the job.
Is that true?
I have to get a piece of metal made.
All right, stop. Let me just have you both raise your right hands. If I need to adjourn it, I will. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. Ms. Breeding,
Yes.
Mr. Richter? Okay, tell me what happened, man.
Okay, my furnace went out in December.
This up 25.
Yes. and
Okay.
My boyfriend, he goes up north, he told me to call Howdy to have him do my furnace. So I called him. I gave him $2,000 to get the furnace. than pay him for the work. He brought me the furnace, hooked it up, and didn't have the plan to go to the vent. So he put a fan on a brick, shoving the heat up into the vents. So every week I would call him. And he kept telling me that this plan was being made. And 3 weeks had gone by and I told him, I said, I can't continue to push the heat up to there with a fan. The gas bill that month was almost $400. And I wasn't really getting the heat in my house that I needed.
Is that true what she said so far?
To a certain point, yeah.
Well, what point isn't it true?
So I told her that I will be back to, I had to call, there's a place in Livonia where I get the metal made, basically just to connect it. That part was true. I needed to come back for that. I haven't, the metal wasn't made yet, so I never returned back. Everything else was done with the furnace thing.
How much of the $2,000 did you earn?
Only made $400 off that job.
And he charged me $800.
$2,000 altogether with material.
So you charged, the deal was you were supposed to install everything, including parts and labor for $2,000, right?
Yes.
And you received all that money, right? And you had to hire somebody else to do it?
I did so.
You have their invoice?
Forgot what I even paid so much. I can get him in my phone. I paid him $800 to finish the job.
Why didn't you bring your invoice?
So I don't have it anymore, sir. But it's done.
Who'd you hire?
Joe Walker.
Is he with the company?
He's a contractor, yeah.
Joe Walker.
Yeah.
You call Joe Walker and have him zoom in?
Don't hit my phone, sir. I forgot the phone, so I just had somebody come to the door and tell me my friend got crushed and killed today, so
Oh my God, I'm sorry.
I'm not.
Why didn't you finish the job and why isn't she entitled to the balance? If it was supposed to be 2,000 and she gave you 2,000.
Yeah.
And she had to pay an extra 800.
So I was gonna go back when the part was done. The part was done, he called me, she's already got it.
This was December,
By
right?
somebody else.
It was cold.
Yes, her furnace was out, the heat was, she had heaters in the basement running. That, I believe, is why her electric bill was so high.
Yes, no.
Are you coming up with 700,
With
man?
the new furnace, it runs less gas, so there's no way it could be running more. There would be no way it could run more.
How are you coming up with $700? Tell me.
After he brought the furnace over, he kept telling me for 3 weeks that this part was being made. He never come up with the part. It was really cold in my house, so I had it done by another person.
I
He
know.
made the plan right there at my house.
So,
It cost me $25 for the plan.
so it was 2,800 is what you paid out on this. Well, why are you only suing for 700?
Because I told him on the $800 that he owed me, he could keep $100 for his trouble, so then he told me it was $800 to carry the furnace down my stairs. And he gave my old furnace to one of his friends for metal. And I said, $800 to carry it in my basement, not hook it up? You don't even have a receipt that I can't even get the warranty on this furnace.
The furnace was working, the only thing that I needed was the final piece that connects from the furnace to your ductwork that blows it into your house. It was literally maybe 10 inches, the piece.
Why did,
He put dryer parts on my furnace, Your Honor.
I read that.
Yeah.
In the state of Michigan, you can use.
I'm just curious as to why you did not sue for 800.
I told him to keep 100 for his troubles because I didn't want to hear about how he carried my furnace.
He kept how much did you keep of the 2,000?
I only made 400, the rest of it to material.
He told me it was 180, then he told my boyfriend it was 40.
And the piece of metal that I had made was 160.
Well, he never had it made.
I did.
And you're under oath. You understand that, right?
Are you talking to me?
Yeah, I'm looking at you.
Yeah, I am.
You're under oath. And you're telling me under oath that you paid $800 to have the rest of the work done.
I did, sir.
Do you have any reason to dispute that?
My friend, one of my buddies, told me that the guy who she hired, he also did more work than what I did. He ran new power, a breaker, a line. That right there's $800, Your Honor.
Is that true?
He did, but he charged me 800 for the rest of the job as well. He only charged me 800 for all of it. Cause he felt bad that I got ripped off. In the middle of the winter, I had no heat. A fan doesn't blow the heat up to my upstairs.
People always rise.
Not,
I don't know why you didn't take care of this earlier. I don't know why you undertook, I'm looking at him.
oh,
I don't know why you didn't take care of this earlier.
Well, the shop that I called told me that they were booked out.
Did-
I had the part made. When I did reach out to her, she said that she's already completed it. On top of that, her boyfriend called me, cussing me out and going bonkers, so I,
Well, I mean.
and you vouch, I understand that.
Anything else? No?
That's it, really. I mean, basically, the 160, I believe, the plenum piece, I believe I would pay that. That part was not finished, yes. Everything else was hooked up though. The return, the gas, the CO2 vet, all that was hooked up. The furnace was functioning.
Inherent in something like this is the fact that it has to be done within a reasonable time. You have a reasonable period of time to fulfill the contractual terms. If you're making people wait for 3 weeks, I don't care if you have to drive the Escanaba to get a plumbing or make it yourself or do what else, you breached the contract. She had the right to go out and hire somebody. She did that. Judgment for plaintiff, $700 plus your filing fee of 68, your total 768. Can you pay that today?
No, I'm not working right now.
When can you pay it?
I start my job next week,
Where?
with sewer and water, Monroe.
How much you going to make?
I think I'm starting out 22 an hour.
Tell me how much you can afford to pay weekly.
Maybe $50.
Do you have a family?
I did. I got 2 twin daughters. They're 9 months old.
When is your first check going to be?
2 weeks from now, from the day I start Monday, next Monday. So it's 2 weeks from now.
So you start on April 27th, right? You pay $50 per week to the plaintiff beginning May the 15th. Okay, so that's the best I can do, Ming. Okay,
can I just talk for 1 sec?
sure.
I gave him the option to pay me weekly, and he kept telling me he was gonna send me $100 through.
If he doesn't pay this, you can move to set aside the installment order. You can subpoena him for a creditor's exam and you can garnish his wages, but you'll have to talk to a lawyer about all of that.
Lawyers.
Okay, so talk to him. If the defendant doesn't pay you as I outlined, then you can undertake collection proceedings, all right?
Thank you, sir.
Go down the hall, both of you, get a copy of the judgment. Good luck. Thank you. What else have I got here?
You're on a Capital One in Scott Wooddoya's.
Capital One. Okay. I thought I called that case, did I not?
You did, but they were in a breakout room.
You. Jim. Capital One versus Voida. Did I put it up there? You got it?
What time is that?
What time was Capital One versus Voida?
9:30, Your Honor.
I swear, are you sure that you have it down there?
I only have 3, Judge, and I don't have that one.
Not here.
It was just here a few months ago. Capital One versus Gardar Voida. 2504390. Names?
Morning, Your Honor. Dylan Clark, P 88474 here on behalf of plaintiff.
Your name, sir?
Good morning, Your Honor. Scott Rollin Voida.
Any resolution on this one, Mr. Clark?
Yes, Your Honor. We came to a resolution in the form of a conditional dismissal.
Okay,
Mr. Voida has agreed to pay the amount of $3,907.48 in 12 monthly payments of $326 beginning on or before May 21st, 2026.
before beginning when?
May 21st, 2026, continuing on the 21st of each month thereafter for that period of 12 months. Should Mr. Voida make payment as agreed, plaintiff's dismissal will be deemed with prejudice. However, if Mr. Voida fails to make payment as agreed, then plaintiff reserves the right to reinstate the action for the full amount minus any money that's already been
You
paid.
understand what he's saying, Mr. Voida?
Yes, sir.
Is it Voida, Woida, correct?
It's pronounced Voida, Your Honor.
Okay, that's what I thought you said, so my apologies. Mr. Voida, he tells me you're consenting to a dismissal, again, in favor of the plaintiff, not in favor of, the case would be dismissed for the amount of 3,907.48, and it's going to remain dismissed, and in fact, will be dismissed with prejudice if you make all the monthly payments commencing on, beginning on May 24th or 26th, and the 24th of every month thereafter until paid in full in the amount of $326. Is that your understanding, and is that how you wish to proceed?
Yes, Your Honor.
Now, if you don't make a payment, if you miss one, he's going to move to set aside the dismissal order, reinstate the case, and enter judgment. Do you understand that?
Yes, Your Honor.
You agree to that?
Yes, Your Honor.
Does she have your permission to sign your name to that proposed conditional dismissal? He would submit it to me, I would sign it, and then you would receive a copy.
That's where they sign, like the court or you guys sign on my behalf, correct?
I'm not going to sign on your behalf, but does Mr. Clark have your permission to sign your name on your behalf?
Yes, Your Honor.
Okay, so you can do that, Mr. Clark, submit it. Mr. Voida, do you have any questions at all, sir?
No, I appreciate your time. And I seen your video online. I am in a car, but I'm parked and I'm not driving. So just FYI.
Have a great day. Thank
You as well, Your Honor.
Your Honor, I do want to know one thing before we're off the record here. The payment date will be the 21st, not the 24th.
I'm sorry. So the payment's going to be due on the 21st, not the 24th. You understand that of every month?
Yes, Your Honor.
Okay, thank you very much. Have a good day, guys. Thanks.
You as well.
Thank you, Your Honor. I do have one more matter in front of you this morning. At 10 a.m., Capital One Discover versus Huey.
Am I able to leave the courtroom, Your Honor? I apologize.
You're all set.
Okay, thank you.
Thank you.
Your Honor, I don't have Mr. Huey here yet.
Oh, I see. Huey. I thought he was saying Dewey. Okay.
I-
All right, Capital One versus, no, Citibank versus Robert Nick Rand. 2505159.
Your Honor, both attorneys are here, but they're in a breakout room.
Okay. Thomas Burton versus James Metzger, 2601197.
Plaintiff is on Zoom. He is out of state. Defendant has not checked in, but it was at 10, so I don't know if if we have to give it till 10:15.
Yeah, I'm gonna have to. Mr. Burton, just bear with me, okay?
Yes, sir.
You're in West Virginia, huh?
Yes, sir.
Okay. Well, Mr. Metzger hasn't shown up, but I give everybody 15 minutes. So if he isn't back by then, I'm coming up and entering a default judgment. So I'm on standstill until the lawyers get out of the break room and or Mr. Metzger and or Mr. Huey show up, correct?
Correct, Your Honor.
All right, we'll take a recess. Thank you.
Guys, to get done with your conversation, so he'll be with you shortly.
Okay, thanks. No problem.
You're welcome.
Thank you. We can't be the worst folks you deal with all day.
Mr. Epps, you're never terrible. You're always great to work with.
Can I have you call my wife?
It's weird that you said just Mr. Epps.
Well, you were obviously muted and didn't have your camera on any longer. So.
Oh, yes, of course.
But
Our TV died last night, so we went over to Sam's Club, bought a new one. So she goes to bed a little earlier than I do. So she said, well, work on it tomorrow morning. Well, I stayed up till later than I care to admit, putting the damn TV up. She goes, wow, you did it. I said, yeah, we got to do something around here to earn your keep.
Motion for summary judgment, actually.
Oh, that's right. That's right.
It appears
Yeah.
my client doesn't believe in answering motions for summary disposition. So I'm going to have to indicate I can't oppose it because I don't think he filed an answer in an affidavit.
Well,
I can say, Your Honor, that we'll likely could probably just move forward with the motion for summary judgment today. Attorney Epps and I have also made settlement discussions. Despite the judgment, this is still most likely to end up in some sort of payment plan and settlement.
yeah, but they did file a response.
Yes, they did.
Affidavit too, sir? An affidavit too?
No. Let me double check that.
I thought it was a two-part requirement.
He's arguing basically that discovery is permitted but we're done with discovery, aren't we?
Yes, we are, Your Honor.
We're not.
Yeah, go ahead.
No, you go ahead.
This attorney tends to send appearance counsel when oftentimes he's making arguments in the answers that are not support. I don't even know if supported is the right word, but not properly. The proper actions have not happened prior to him making the arguments, such as arbitration. So I believe we could just move forward with the motion for summary judgment.
Go ahead.
Okay. Sorry, 1 second. I clicked off to go to his answer. Let me just bring it up 1 sec.
I think the term's called a responsive pleading, and none of the people I sub for ever seem to know what that means.
All right, I'll read this in real quick. This motion is
Stop
being brought under
subbing for some
MCR.
of those people, Mr. Epps. I don't know what to tell you.
I'm sorry, sir?
I said, maybe you should stop subbing for some of those people or all of them.
Nah,
Well-
don't stop subbing for him, Mr. Apps. What fun would we have?
They pay me for doing this, sir, and otherwise I have to find a real job. So I'm not going to kill the goose.
Go ahead, Mr.
Sure thing.
Mr.
Motion. I'll do this real quick. Motion is brought under MCR 2.116 C9 and 10. Defendant has failed to state a valid defense to the claims asserted and has failed to assert facts giving rise to issue of material fact. We attach as Exhibit A copies detailed account statements showing knowledge and use of the account. Defendant's answer potentially not filed correctly. Doesn't really touch on any of that particularly well. Brings up arbitration, even though they never tried to compel arbitration. So based on our filing, we basically stand on our document and ask for motion for summary judgment this time.
Any response, Mr. Epps?
I think it was a very eloquent explanation, sir, and I have no defense.
I'm going to go ahead and grant plaintiff's motion for summary disposition pursuant to provisions of MCR 2.116 C9 and C10. I'm going to ask you to give me your breakdown and we'll enter a judgment now. Okay,
Sure thing.
counsel? Go ahead.
Let me bring it up. Second. All right, so we have original damages of $2,640.46, court costs of $157.26. That's 75 in filing, 20 for motion, 62.26 for service, for a total judgment amount of $2,797.72. This particular creditor does not seek any statutory interest rate.
All right, judgment will enter. So summary disposition granted, judgment will enter in the amount of 2797.72 in favor of plaintiff and against defendant. So you can submit your judgment. I appreciate it.
Your Honor, I
very
do
much.
have a judgment
I
that
was gonna
was submitted
say,
with the motion, so I've
It's page
sent it to your
15, but I
box.
can resubmit if necessary.
Whatever you
I've
want,
sent it
Jen.
to his
Bring it.
signature box. You're good, Judge. It's there for you to sign.
Excellent.
It's in the back of the packet?
No, on M file. When you go in
Right.
to log in later, it'll be there.
Got it. You're all set, gentlemen. Have a great day. Thank
Thanks.
you.
And let me just check in. Can I just check in real quick on McDaniel? It was still on the ROA, but we did file a dismissal.
That when we have off, Your Honor. We
Okay.
did get the dismissal.
So you're
Thank
all
you.
set.
Thank you very
Thanks.
much, Your Honor. Have a good one.
Thomas Burton versus James Metzger, 2601197. Mr. Burton, state your name.
Thomas Burton, sir.
Oh, this isn't good. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes, sir.
Your page, my page cuts off. You gave him 144611 for custom what? The V there is all I see.
Oh, they're custom truck parts, sir.
And they took the money and never provided the parts?
Yes, sir.
And are you still out $1,446 and
Yes, sir.
11 cents?
That's correct, sir. Okay, you're welcome.
I'm gonna go ahead and give you a default judgment. This is your day to be a lawyer if you want. I'm just kidding. Anything else? You have
No, sir.
$1446.11 plus you have your filing fee in the amount of $18. Do you have any other out-of-pocket expenses?
Yes, Your Honor. $51 to send him additional documents. That was
To
sent
send
last
who
week.
additional documents?
Mr. Metzger, there were follow-up documents that were submitted to the court and submitted to him as well.
And Your Honor, his filing fee was $50 and there was an $18 service fee,
Oh.
so it was $68 total.
What's he talking about with the documents, Jennifer? Was that in conjunction with the case or beforehand?
That may have been him sending him the documents that are printed in your packet, because he would have
Nice.
mailed a copy to opposing party of everything he was filing with the court.
Yes, Your Honor, that's it.
Where'd you have the documents printed at?
I printed them myself and then I had the UPS store ship them for me.
I
Certified
see.
mail.
And that was $56?
$85, sir.
So I got 85 plus 50 is 135 plus 18 is 153. On my math, you're getting 1599. And if you think I'm wrong, please tell me. 1599.11, because I'm giving you the $85, the 15 and the I'm sorry, the $85, the 18 and the 50. So 1599.11. We will send out the judgment and you're all set. I wish you well.
Thank you, Your Honor. I appreciate it.
Have a great day. Thank you.
One
Sorry
last
you-
question, Your Honor.
Yeah. If
Once
he
you
doesn't
guys
do
send-
anything in 21 days, we're gonna have to figure out a way to collect. You could do a creditor's exam and perform that by Zoom. He'd have to come here. But you're gonna have to, I would talk to a lawyer, or you can do the best research you can online. I can't really advise you. You can garnish wages, you can garnish bank accounts, you can garnish tax returns, but you're gonna need other information to do that. So
Your
probably
Honor.
gonna want a creditor's exam, require him to bring all of his pay stubs and tax returns, house deeds, bonds, stocks, car titles, etc. Okay?
Your Honor,
Understand,
if
Your
I
Honor.
may.
Yeah.
There's a website that might help him that he could do some looking at. It's michiganlegalhelp.org. It's all one word.
Michigan Legal
Help.org.
Help.org.
Help.org. Okay.
Okay.
And on our math, we came to $1,611. I know it's $1, but that was the total amount once we added everything up, Your Honor.
Well, you got 1446.11, right?
Yes, Your Honor.
And then you got 18 and 50 in
51.
costs, which is 68, plus 85, which is 185, 135, 153 plus 1446.11 should equal 1599.11.
The mail-in or one of the processing fees was $51, not 50.
All right.
End of the day, Your Honor, it's $1. I'm good.
No, I'm going to change it for you.
It was the filing fee, Your Honor, for 51.
No, I get it. So it's $1,611, right?
Yes, Your Honor.
Yep, that's what I get with that extra dollar. You're all set. Have a great day. Thank you.
Thank you, Your Honor.
Bye now.
Bye.
Capital One versus Huey. Thaddeus O. Huey Jr., P504223.
Dylan Clark, P88474 here on behalf of plaintiff.
All right. Is Thaddeus Huey here?
He's not checked in on Zoom, Your Honor.
Okay, you can go ahead and proceed, counsel.
Your Honor, I'll rely mostly on the brief and keep this short, but the credit card statements attached to plaintiff's motion specifically required monthly payments, and Mr. Huey defaulted by failing to make the required payments.
Can you speak up or something? I don't know.
Yes,
I'm not catching the rip.
Apparently, I need to invest in a new microphone. I apologize for that.
That's all right.
No, in this matter, there's no question that Mr. Huey defaulted under the terms of their credit card agreement, and as such, the default provisions of the credit card agreement became applicable. There is no genuine issue of material fact in this matter, and accordingly, plaintiffs entitled to judgment in the amount of $7,520.10, representing damages in the amount of $7,354.40, plus court costs in the amount of $165.70, with interest accruing at the statutory maximum of 13%.
You got 75, 20, 10, is that right?
75, 20, 10, Your Honor.
All right. Plaintiff's motion for summary disposition is granted. There's no genuine issue as to any material fact. So pursuant to MCR 2.116C10, the motion's granted. Judgment will enter 75-20 and 10 cents. You're all set. Submit your judgment. Be good.
Your Honor,
Thank
I
you.
have that proposed judgment already, so it'll be in your box for signature.
Perfect. Great. Okay. Thank you.
Awesome. So just to clarify, the order submitted will be signed?
Yes.
Yes.
All right.
Yes.
Thank you so much. Have a great day, everyone.
Have a good one. Ford Motor Company versus Tilira L. Mosby.
Your Honor, that's a 10:30. The parties just checked in and I just put them into a breakout room.
Do I have Independence Capital versus Pavlich?
I do not yet.
Do I have Brook Gorham versus Eastern Account Systems of Connecticut?
I do not yet.
Do I have Amy Lawrence versus Greg's Auto Service? 2600529. You provided your name,
Henrik Murad.
your name. I'm going to ask you to both raise your right hand again. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
I do.
All right. I got some questions for you. You brought me this guarantee. This is over the lease. Was there not a separate business agreement where you purchased assets?
Yeah, I have the purchase agreement here.
Well, why didn't you give me that? That's what I wanted. Can you hand that to my court officer?
That's the purchase agreement that we did. That's the whole fund.
No, this is the personal guarantee. This is the only agreement you guys entered into?
Yeah, that's when we did it at the lawyer's office on Ford Road, and that's the papers that we did. And that states the other owners' names and
That you're gonna pay the lease. Who owns the assets now?
the owner of the building, their names is Ali Saad and
Do you know this owner, whoever owned the Greg's Auto Clinic when you bought it?
it says it on the paper, on the second page. Greg's Auto Clinic, that's what.
Right.
They own. Yeah, on the second page at the top, it said, Hussein Hamadi and some other name, Allah.
Hussein Hamadi and Allah Talib, right?
Yes,
Do you know those guys?
I don't.
Did you know them before you purchased this?
I had no clue about it. Nothing.
How did you get in contact with them to purchase this?
My partner knew that they wanted to sell the business. And so we talked to them, then we found out the building is not theirs. So we went to the owners of the building, we talked to them, and then we did the agreement. And I took over and I changed the name to Greg's Auto Services LLC. They had it as Greg's Auto Clinic at that time.
So everything, the agreement that you entered into, you have no other agreement other than this.
That's the only thing I had.
So who did you contract with the tenants of Greg's Auto Clinic?
Yeah, Twins. They're called Twins Auto Sales. They have a lot of dealerships. So that's the people that I've purchased the business from. That's who I'm renting as of today from them. Twins Auto Sales. Ali and Abdullah Saad.
Yeah, but
The other people, Your Honor, they were renting also from Ali and Abdullah Saad, the twins.
and now you're renting direct from the twins.
Yes.
And this is the only agreement you have.
So, like, did the agreement.
That's why I was confused when I said they took it to a sister shop in Redford, which Twins Auto does have a dealership in Redford, but this other dealership is
Okay,
not.
let's talk about what kind of car repairs that you had to have done.
I had a whole engine put in, and
When was that again? Because I don't want you to think I remember much.
no, I know you have a lot of cases. I put the deposit down for my engine on October 7th of 2024.
And you put it
Yes, that's the end. Because then I had to pay.
October 7th of
The
24.
whole engine was 55.89.
Wait a minute. You put a deposit for the engine on October 7th of 24?
Right, and then I didn't get it back until.
Wait a minute, slow down. And then how much was that for again? 55?
55.89.
And that was with the predecessors to this gentleman and his company, right?
I assumed it was the same guy working with him. Like I said, I've never dealt with the same mechanic more than once, ever, throughout this whole process through any shop.
Okay, so I'm gonna need to take my time on this. I'm sorry. Let's start completely over. I apologize. I didn't write. So you gave him 55.89
Was the cost of the whole engine.
on October 7th of 24.
Correct.
And had the work been performed as of then?
No. They took it out to the other shop in Redford and
On their receipt, it says completed on,
All right, I just want to know.
Yeah.
What other shop? Was this Greg's auto clinic?
yes. And then they took.
And
it
who
out.
was the principal of Greg's Auto Clinic again? Can somebody tell me?
she could,
What do you mean?
Who was the
Well, that was the predecessor.
Someone named Sam, all he told me was his name was Sam.
Do you know who that was?
I think that's the guy from previous, Hussein Hamadi.
Okay.
Stand that over here.
All right, slow down. I know, but let's just not start. I'm trying to follow this whole thing here. So you gave them money. Was the work completed or not performed when you?
No, they took it out.
Wait, you gotta let me finish. On October 7, 24, you wrote them a check for $55.89,
No,
correct?
I gave them $3,000. I didn't pay the balance till I picked up the car,
When did you give them $3,000?
October 7th, 2024.
All right, but you still were gonna owe a balance of $25.89,
I
right?
picked up my car, correct?
All right. And that you think, or so you think at least, that was when Hussein Hamadi and Ayla Talib were running Greg's Auto Clinic, right?
Yes, Your Honor.
Hang on. Just let me get my bearings here. All right. So you drop it off on October 7th of 24.
Correct.
You pay them $3,000 and agreed to pay $55.89.
Correct.
Then what happened? The
Uh,
vehicle was taken where?
to Fast Lane Auto on 8 Mile Road in Redford.
On 8 Mile in Redford. And that's where the work was performed?
Correct.
And do you know if Hamadi and Talib owned that?
That I don't know. That I don't know. The same person I dealt with that took my car there is no longer there, and now there's been supposedly 3 new owners since then at that shop as well.
Do you know for a fact that she gave it to Hussein Hamadi?
The person I talked to told me his name is Sam. That's the first time I'm hearing.
And you
it.
think that's who?
Hussein Hamad, that's saying it.
All right, so the work's performed out at Fast Lane Auto on 8 Mile in Redford. And when do you pick up the car?
On the receipt, it says she picked it up on 10/7, one.
That I don't know why they put that, because I know they didn't do an engine the same day. That's
No, you dropped it
That's
off on
Chevy.
8/20. And then work completed on their receipt, it says 10/7. On first.
But they can't be, right? Because I didn't pick it up from Greg's. I picked it up from 8 Mile.
Yeah,
Okay, so wait a minute, slow down. Wait, let me ask you a question. Just wait a second. Wait. So you're telling me you have documentation that indicates they dropped it off on August the 20th, 24?
no, I'm seeing it off of her papers.
This courtroom moment turned intense because the judge had clearly reached his limit. A young woman stood in front of him after disappearing for nearly 3 years, missed court dates, unpaid fines, ignored probation conditions. And now she was back, trying to explain everything. But the judge wasn't interested in excuses anymore. He reminded her straight, this isn't just about money, it's about responsibility. You had time, you had chances, and you chose not to show up. Then things got even worse. The judge pulled up her record, and what he saw shocked even him. Multiple warrants, repeated failures, unfinished programs. Every time she tried to explain, the judge stopped her and brought it back to facts. Because in court, your story doesn't matter if your actions don't match it. But then, something changed. Instead of sending her straight to jail, the judge gave her one final opportunity. A strict one. Pay the money, complete the required program, show proof of change, and most importantly, come back prepared. Because this was it. No more extensions, no more excuses. Just one last shot to fix everything before it's too late. And even after everything, the judge said something powerful. That's the beauty of the system. Even after disrespect, you still get treated fairly. Think about this. If someone ignores the court for years and keeps making mistakes, do they deserve another chance? Or is there a point where it's too late? Comment. If you found this real courtroom moment powerful, don't forget to like and subscribe for more intense cases like this.